Good afternoon, ladies and gentlemen. Welcome to the Managing the Risks of Model Sharing, What You Should Know webinar. This is a webinar brought to you by AIA Contract Documents. Before we get started, there's just a few administrative items. You will be receiving the recording of today's webinar, as well as the PowerPoint and a short survey at the end of today. So by the end of today, you should receive recording, survey, as well as a PowerPoint for your reference. This presentation is protected by U.S. and international copyright laws. And this program is also eligible for one AIA learning unit. When you registered for this program, you entered your AIA member number if applicable. We're going to use that information to report your credit for this program, and it will appear on your online transcript. Please give at least 1 week for the credit to appear on your online transcript. And now I'm going to turn it over to our presenter to go ahead and introduce themselves. I'll start off with Mr. Patrick O'Connor. Pat, please take it away.
Thank you, Asti. Hello, everyone. Good morning or good afternoon, as the case may be. I'm Pat O'Connor. I'm actually not with the firm of Faegre, Baker & Daniels. I'm now with the firm of Faegre, Drinker, Biddle, and Reith, because we have merged since the time that we actually had this PowerPoint made. So, but it's, I'm still in Minneapolis, and I still do what I did before the merger, which is, I've been practicing construction law with an emphasis on, larger construction projects for, I don't know, close to going on 40 years now. And I also am outside counsel to the AIA's Documents Committee. And I've spent a fair amount of time, on building information modeling documents. And I've spent a fair amount of time with the fellow who shows below me, on this PowerPoint, and that's Jim Bedrick. And I'm going to turn it over to Jim for his introduction.
Thanks, Pat. Yeah, I'm Jim Bedrick. I'm an architect by trade, but I've worked all three sides of the owner-architect-contractor triangle. So since 2011, I've been an independent consultant working at the interface of workflow design, technology implementation, and collaboration support. I guess I'm in my 12th year of a 10-year commitment to the Documents Committee. I've worked on the A-series docs, the construction documents, as well as the digital practice documents. And I'm also co-chair of the committee, the BIM Forum committee that puts out the BIM Forum LOD spec, if anyone's familiar with that. If not, we will be getting into that in a little bit of detail later on. So what we want to do today is, by the end of the hour here, we want to understand the risks and rewards of model sharing. We want to have a working knowledge of the AIA digital practice documents, and we want to understand the relationship between those documents and the BIM Forum LOD spec. And then understand how these docs and the LOD spec together help manage and allocate the risk of sharing models. So, Pat?
So, I'm a lawyer, and so unfortunately, because I'm a lawyer, I'm the one that always has to talk about risks. And so I'm going to focus, probably a little bit more on the risks of model sharing. And Jim will probably spend a little bit more time dealing with the benefits of model sharing, but that's part of what we want to try to cover today. There are, however, risks with regard to, designing buildings and building buildings from, 2D or two-dimensional drawings as well as from models. So, there's no one risk-free environment. It's just a little bit different kinds of risks. So we're going to talk a little bit about those, and we're also going to talk, about how, modeling and how contract documents with respect to modeling are a good way to control the risks while achieving the benefits. So that's the primary focus of our discussion today. So what does it mean to share a model? I mean, what are we, from a standpoint of risk and reward standpoint, what does it mean to say to share a model? And the key concept, if you don't get anything else out of this program, and I suspect you're going to get quite a number of things from this program, but one of the things that you need to walk away from in this program is that from the standpoint of sharing models, and there's, Jim will talk a little bit more about what we mean when we talk about sharing a model. What is a model? Are there, what's the stage of sharing models? Just like the drawing process, there's a certain process that one follows, an iteration of the development of the design, and that's the same whether or not you're using 2D drawings or whether or not you're actually using modeling. But modeling presents additional issues, and so from our standpoint, one of the things we always ask ourselves is, why are you sharing the model? What do you intend to have the party with whom you're sharing the model do with the model? So we ask questions like, why was it produced? What were you told by the recipient about what it would be used for? And what is the communication trail that follows the model? Because at the end of the day, the liability aspects of model sharing depend largely upon what the parties' expectations were with respect to what they could rely upon with respect to the information contained in that model. So what are the reasonable expectations as to the completeness and accuracy of the model? Difficulties in managing these expectations have led to the current practice, it's still the current practice, of broad disclaimers. And we'll talk a little bit about how successful these broad disclaimers are. In other words, disclaimer meaning that you can have my model, but you can't use it for anything. How useful is that? And what are the consequences of these broad disclaimers? And then, does the reasonably inferable standard apply? It's a very common standard with regard to the 2D drawings. The contractor is to be responsible for building not only what actually appears on the 2D drawings, but also what is reasonably inferable from the 2D drawings. So that's the key concept to keep in mind is reliance.
So, okay, given all these risks and the complications, why would we want to share models? First of all, if somebody asks for it, the owner may well ask for the model. More and more owners are asking for models at the end of the day to manage the facility once it's handed over. The contractor may want the model to do the construction level coordination as well as there are other very useful processes that we'll talk about in a minute, but that can be used as long as the contractor can rely on the model. And then, of course, the engineers in the design team will want the model as background for their own work. The contract may call for it, and that's first of all, the issue of the owner wanting the model for construction for facilities management is often written into the contract. So what are the benefits of this? First of all, clarity. This is Daniel Liebeskin's Denver Art Museum. It was built quite a while ago, but Mortensen was the builder, and this kind of thing is very, very hard to articulate in the 2D drawing. So you can see here's this connection. Now, obviously, the gray part here is that's not the architect's responsibility, right? That's the fabricator or the steel erector. But all of this colored pieces, these are the design team's responsibility. And how they come together in the angles here, that tells the fabricator what they have to do to make the connection. So this kind of thing is extremely hard to articulate properly in 2D drawings. Much more clear if you can pass on a model and the fabricator can rely on these colored members being exactly where the model says they are. There are some automated construction processes that are enabled. For instance, laying out MEP hangers. The locations are in the model. Well, they can be taken out in a digital file and transferred directly to a total station and then located in the field. This process is hugely efficient and effective. DPR did it on the UCSF Medical Center some years ago and laid out over 200,000 anchors with 43 of them in the wrong place. That's a 0.02%, 0.02% error rate, and I don't think you're going to get that in any kind of a manual process. It was also 4 times as fast and about a quarter of the cost. So this idea that you could have to have, you have quality, time, and cost, and you have to sacrifice one to get the other two is put to lie by this sort of process. This really is better, faster, cheaper, and it depends on being able to rely on that model. Efficiency. Owners are starting to really chafe at the idea of paying the contractor to rebuild a model that they already paid for the architect to build. Now, the contractor, the problem here is if the contractor can come back and say, well, I can't, I have to rebuild the model because the architect says I can't rely on it. And then the owner starts telling the architect, well, why can't the contractor rely on the model? Isn't it right? So this gets into quite a bit of back and forth, and it just, that sort of thing is put to rest as long as there is some aspect of a reliance that the contractor can rely on that model. Communication and collaboration. It's sometimes called Big BIM and Little BIM, sometimes Social BIM, Lonely BIM. When a number of us were in Orlando once, we decided also that it might be Happy BIM and Bashful BIM. But the idea is that BIM is a hugely effective collaboration and communication tool. And to say that you can't rely on it just really dilutes that the effectiveness of the collaboration and communication. In a BIM execution plan, this is a diagram from the Penn State BIM execution plan template that many of you have probably seen. All of these models down here are, all of the items there are models which are information exchanges, which means they have to exchange information from one firm to another. So that really is depends on reliance on the model. Some of the other items here under collaboration communication, obviously system coordination, estimating. A lot of owners want cost checks at one or more points during the design. The estimating process is much more efficient if you can rely on the model for a lot of quantities. Prefabrication and offsite construction, which is kind of the wave of not the future, though it's the wave of the present. That really depends on relying on these models. If you're trying to, if you're building something on site, you can make it fit. You can grind it and hammer it and bend it and whatever. But if you're building it at 500 miles away and shipping it to the site, the accuracy of the dimensions around where that piece is going to go and what the piece is being fabricated to become much more important. And a properly designed model can be hugely effective in supporting this process. Lead credit planning and tracking. It's somewhat akin to estimating. There's a number of the lead credits that are based on aspects of materials, and you can monitor that, whether you're getting that credit or not. You can monitor that through the design process and on into the construction process, as long as the model, again, is reliable. Facilities management, that is sometimes said just FM, okay, but it covers a huge range of uses, some of which are dependent on that, the reliance on that model. For one thing, owners want that model for remodeling and repurposing in the future, and that requires accurate placement of elements and the ability to rely on it.
Well,
okay,
as promised, as promised, because I'm the lawyer, I'm going to be talking about risks. So what are the risks with regard to models, creating models, and sharing models? And again, obviously, most of the risk, from modeling comes when you actually give the model to somebody with, some expectation that individual or company is going to do something with the model. So, what are the risks of modeling? And more importantly, what are the risks with regard to sharing models? And the risks change depending upon when, you're at what particular stage of the development process. It's one thing to share models at an early stage, like schematic stage, when there's no expectation that the model is going to be used for anything other than perhaps just, general, understanding of, the size of the project or whatnot, but there's not a lot of significant reliance. So it really depends upon what the circumstances are. But at the end of the day, most risks with regard to modeling boil down to communication risks. So for example, does the model contain errors which can cause loss? Well, it is certainly possible that models can. The real question is it more likely that models will contain errors than 2D drawings? Because we have to be, we're not really talking about risks in the abstract. We're really talking about, is modeling riskier or less risky than not modeling and using the traditional 2D drawing process? And so, from that standpoint, obviously models can contain errors, but so can 2D drawings. Does the model contain information that might be relied upon causing loss? Well, yes, obviously it does. But some of the unique things that models sometimes give rise to are things like, for example, it's not uncommon for, during the process of modeling to, put placeholders in, for example, where, windows or doors might be. These are just placeholders. They're not really intended to convey, the actual shape of the door or the location of the door. They're just simply a placeholder. And so, again, it's a communication error. If the party that is receiving the model doesn't understand that to be the case and believes that that actually is something other than just a placeholder that's likely to change in the future, then there can be some problems. Again, it's a communication error. Is there missing information? Yes, that's a possibility. But in reality, one of the things that modeling does that's unique is not so much missing information, but an incredible amount of additional information that may not necessarily be, germane to the communication that the model maker wants to convey. From what I understand, I don't do modeling because obviously I practice law, but what I understand is that it's not difficult to populate models with a lot of information, and that some of that information, or in some cases quite a bit of that information, is not necessarily germane to what the model maker is intending to convey. And that's one of the risks that's relatively unique to modeling as opposed to 2D drawings. It's a lot of work to put in additional information into a 2D drawing. You have to actually draw it in many cases, whether that's computer aided or not. It's not much easier when in a modeling environment. And again, at the end of the day, it's really boils down to what is the purpose for which the information is being conveyed. So let's talk then a little bit about legal consequences. Obviously, there's potential liability in the event that information is incorrect. That's not unique to modeling. That's simply that's the part and parcel that comes with the design process and the model creating process. And it's not, from my vantage point, there's nothing inherently more risky about modeling in terms of conveying incorrect information than over a 2D drawing. And Jim may have a different opinion on that, but I've not seen that anecdotally in the marketplace. There can be uncertainty as to the expectation of reliance, and that's a key reason why contract documents are created for modeling, because it's very important that all the parties be on the same page with respect to what is intended to be relied upon when they receive a model. Because again, the model can contain a lot of information. Some of it can be relied upon for certain things and not for others. For example, a model may not be sufficient for purposes of actually building the project, construction, but it may be appropriate for pricing, for going out and actually selecting cost estimating. So there has to be clarity with respect to what the parties understand and expect with respect to relying on the information in the model. And then there's a back and forth as to whether or not the model should become a contract document. In the AIA scheme, models are not contract documents. By contrast, in the consensus docs scheme, models are contract documents. The safe position is, in the current practice, is probably the AIA model, which is not to make the model a contract document because of the issues that we've already discussed about, the fact there can be too much information, not enough information. There has to be really an understanding of what the model is going to be used for. There is, however, a counter argument for making the model a contract document, and that is if the model is actually going to be used, by the contractors, by the trades in actually building the project, then the model begins to look and feel and sound a lot like a contract document. Or in other words, a contract document speaks directly to the scope of work that the contractor must perform. And so it really, it's an interesting question, but until parties, get comfortable with one another in terms of their modeling expectations, the safe route is not to make the model a contract document, instead to pull a 2D drawing set from the model for purposes of making the construction documents and as the contract documents. So how do we address these risks? Well, the current practice for most design professionals, and to a lesser extent for contractors as they send their models around to other trades, is to simply use the same practice that was developed with regard to CAD drawings. When owners wanted the design professional's CAD drawings, the design professional, to the extent that it agreed to provide those drawings, it's really computer-aided drawings, was to submit the drawings to the owner with a disclaimer. This one is, this one conveys the intent of the disclaimer, although it doesn't necessarily use the common disclaimer language. But it basically does, this disclaimer basically says, this model really looks wonderful, but you really can't use it for anything. You really can't rely on it for anything. And it's, and that includes everything. So that's a basic disclaimer approach, which is to, submit, to take that same approach that we used in the CAD world and apply it to, to the modeling world. But in the CAD world, it was pretty clear that, the contractors were really using, the 2D drawings for purposes of actually constructing the building. It's much less clear in the current environment where contractors have, portable, tablets available on site that they can pull up the actual models on those tablets. And in many cases, they are using models for purposes of construction. So the world's become a little more blurry as in terms of what the model is being used for and the expectations with regard to modeling. And so the common approach of just providing a model with a blanket disclaimer has become more problematic in the current environment. So Jim, if we go to the next PowerPoint, we'll see that. So with regard to modeling, there's a question as to whether or not a blanket disclaimer is really going to be effective or not. Because at the end of the day, if there is an underlying expectation that the recipient of the model is going to be using the model for some specific purpose, and the provider of the model understands that the recipient is going to be using it for a specific purpose, like cost estimating or like actually building the project, then simply providing a disclaimer that says, oh, by the way, you can't use this for anything, may not be as effective as you might expect, particularly as effective as it was in the old environment, where oftentimes the CAD drawings were given to the owner at the end of the construction process. So that's the first thing. It may provide some false belief as to, legal, as to a legal shield. That's not really the case. And then finally, there is a question as to whether or not the practice is really consistent with the party's expectations. If it's not, then why are we sending these disclaimers? So the bottom line is that unlike the CAD world, the modeling world doesn't fit the traditional disclaimer approach quite so neatly. So that's one of the reasons why the AIA, back originally in 2008, started to approach, a set of contract documents to try to address this issue of, how do we set the ground rules for the parties' expectations and their communications with respect to modeling. And the way the AIA has done that under the current regime is that there is, the primary document is the AIA document E203, which is the Building Information Modeling document. And then there are two G documents, those are, the form documents. So the E document is a contract document. It's a document that's actually signed and executed by the various parties. And then the G documents are oftentimes incorporated into that E document, but are not necessarily signed by, by the parties. They're kind of like the G documents in the AIA, lexicon signify a form document. And so the G201 is the project digital data protocol. And we're not going to talk about that too much today. That deals with, for example, whether or not emails will suffice for purposes of the notice requirements that are set forth in the parties' agreement, those kind of issues. But the one that really focuses in on modeling is the G202 document, and that's the Building Information Modeling Protocol form. As a lawyer, I'm fairly comfortable with filling out the E203, even though, I really don't do any modeling, but I'm comfortable enough with the modeling concepts and what the issues are from a legal standpoint that I can get through the E203 relatively easily. And the AIA has a guide, and that's the last document that's referenced on this PowerPoint, that helps significantly I would refer you to that guide, when you're looking at, the E203 or using a document for purposes of, addressing the modeling required in a particular construction project. So I can handle the E203. The G202, however, is well beyond my expertise, because that gets into the weeds with respect to the modeling protocols. That's really in Jim's world, and that's one of the struggles that all parties had. Whether the AIA or the contracting trades or the consensus docs folks, the struggle is to create a useful set of contract documents that can be, understood and utilized by the parties, that are negotiating construction contracts. And unlike, the typical agreement forms where, legal counsel and, the parties that are comfortable with negotiating contracts, the actual protocol forms for modeling require a certain level of understanding that oftentimes is not shared or really resides in the people that actually do the typical contract negotiation. In some respects, it's a little bit like the insurance provisions that you'll run across in large construction projects. They can get quite complex because they're bringing into the discussion another world, which is the insurance world, and there's a lot of separate vernacular that that oftentimes lay people don't understand with respect to insurance coverages and insurance policies. It's a little bit like that, but actually gets even a little bit more dense with regard to modeling. So next one, Jim, I'll move real quick here. The E203 is the agreement form, and because it's the agreement form, it is intended to be executed, between the various parties. So it flows down, from the owner through the design teams, to the architect, and from the architect down to its consultants. And then it flows from the owner down to the contractor, and then from the contractor to its subcontractors. There's some expectations of reliance, between the design team and the construction team, but there's no straightforward contractual relationship between the two. Although in some respects, they're third-party beneficiaries of one another with respect to making sure that all of the parties that are going to be involved in the modeling process are covered by the agreements. So I think let's go to the next one. So
there's a bit of a lag
the E203,
Pat, so.
Excuse me?
There's a bit of a lag here, so you'll have to wait for the other one.
Okay.
To come up.
Okay. So the E203, as I mentioned before, is attached to the contract documents, and it establishes it provides for the establishment of the protocols. In other words, it requires the parties to set forth the ground rules upon which modeling will be provided and will be used on the project. It doesn't actually contain the protocols. They're oftentimes in the G202 document, and actually in separate documents as well that Jim will talk a little bit about. But it at least sets it places upon the parties a requirement that they actually start to implement protocols. And then, again, it requires the parties to incorporate that into their contract documents. So we'll go now to kind of the linchpin. If there's one contract provision in the E203 that really kind of sets the stage for how significant of a modeling protocol or process is going to be used for the project, it's this particular article, Article 4 in Section 4.1, because that's the article where the parties elect as to whether or not they're going to do modeling really for their own sole purposes, and they're not really going to provide the models to one another for anything other than at the recipient's sole risk. In other words, we may model and we may actually give you our model, but you can't use it for anything. It's like the disclaimer approach with regard to CAD drawings. Or two, the second one is where the parties actually agree to develop, share, and rely upon models. In which case, if that box is checked, and it's our expectation that that box is going to be checked, because if you've gone to the trouble of actually starting to enter into these agreements, you're not going to be doing more often than that number one. You're not going to do the first box, because if you're going to do the first box, you're probably just not going to do the documents at all. The real trouble is if you check the second box and then you don't actually go ahead and establish the protocols, then you're back to no reliance. So if you're going to check this second box, then the parties have to go forward and actually establish the protocols. The second box simply says that we are going to share models and there will be reliance upon models, but reliance as defined by the various protocols that we have created. And that's the G202 document. The G202 document establishes the modeling protocols, specifies the authorized uses for models, and so as a general rule, and Jim will kind of go through this in more detail, the general rule, the models are set forth on what's called a level of development basis. In other words, they start out any particular series of models will contain, lots of information that may be at a level of development beyond, what other pieces of information are at in the same overall collective model. But the overall collective model is then characterized as bearing a certain level of development, and that bearing tells people who are conversant in modeling what they can do with that model, how they can rely upon it, and that's really set forth in the G202. So the BIM documents, are intended to provide an alternative to the broad disclaimer approach because, frankly, it doesn't really work all that well in the model environment, and it provides the framework for the parties' expectations upon how they can rely upon the information contained in models. So I think, Jim, I'm going to turn it over to you.
Okay, thanks, Pat. So what this disclaimer approach boils down to is that some of the information in the model is not reliable, so don't rely on any of it. So that is clearly throwing the baby out with the bathwater. It really diminishes the model's usefulness as a communication, coordination, and collaboration tool. What the AIA developed when we took this on in 2008 was this specified use approach. We agreed, yes, some of the information in the model is not reliable. And this really is the key, as Pat said earlier, that there's information in there that you don't intend. So only rely on what I say you can for the purposes I say you can and to the degree of precision I say you can. So this approach then completely takes off the table any of that unintended information, because obviously I'm not going to say you can rely on it if I don't know what's in there. So how do you state this series here? What can you rely on? What purposes and what's the degree of precision? Well, that's where the LOD schema comes in. Obviously, systems travel through this journey from conceptual to final design at different rates. The structure usually leads everything. Things like casework and finishes come last. So at any point, these systems are going to be at different stages of completion, but they all tend to, or most of them tend to hit certain common milestones. They may start out with a concept, and this may be just a massing model, and you might have some costs, some square foot costs attached to the floor plates. But then the next next point, you start putting in generic placeholders. So here we might have a rule of thumb depth for the floor structure. We know the grid spacing, that sort of thing. The next stage is specific assemblies. Now we replace those placeholders with actual assemblies and elements that are engineered and placed properly. And then sometimes we go on further to details. We labeled these then level of development 100 through 300, or pardon me, 100 through 400. Very little in a model will ever get to 400. 400 is usually what happens when the specs call for a shop drawing. So these definitions then, the 100 is conceptual. It might be graphically represented, or it might be just a symbol. Or it might be that the information about that element can be gotten from other elements, such as a square foot cost from a floor plate. Next stage is generic placeholders, and this means that they are all approximate in quantity, size, shape, location, and orientation. So if I have LOD 200 elements in the model, they are not reliable. They are approximate. They are not necessarily in the place that the designer intends them to be. Then we get to 300 specific assemblies. So if you look at walls, for example, at 200 might be an early schematic that where we use things like generic 6-inch interior walls and so on. We know there's a wall about at that location, but we don't know what the wall type is, and we don't know exactly where it is. At 300 now, we know the wall type, and we know its location. And then again, 400 detailed assemblies, that is the shop drawing or fabrication level. So the G202 then has a table in it that allows models to be profiled according to these levels of development. All right, building systems are listed down the left-hand side in a Uniformat 2010 breakdown, and then there are milestones and deliverables as sets of columns. Okay, there are the standard milestones, maybe SD, DD, and CD, or you might have midpoints of those. And then there are other deliverables that you might have along the way as for things like cost checks and coordination and so on. These are information exchanges. So for each system that's actually included in the building, they get an LOD at each stage, which is likely to increase. They don't always go all the way up to 300. And then there's a responsibility. Who is actually going to model that element? So this is really the embodiment of this specified use approach. Okay, and this probably is the key piece of information from this whole presentation. This allows the specified use approach. It allows me to state exactly what can be relied on and for what purposes and to the degree of precision. So this clearly indicates what is reliable, what is accurate in the model, and what is not, what is approximate. So, okay, that was all fine, but what we found in practice was that just trying to rely on those one paragraph definitions, they were could be widely interpreted. What I think of as an LOD 200 door might not be what you think of as a 200 door. So the BIM Forum, if anyone is not familiar with it, it's an organization supported by both the AGC and the AIA, as well as a number of other professional organizations. Very interdisciplinary group with conferences once a year. Well, in that organization, we got together and decided to interpret the various elements at various LODs. We'd interpret the AIA definitions. So the result was this LOD specification, all right? And you can see here that it is an interpretation of the AIA's definition for various building systems and components. And when we put this together, we weren't saying that this was the right interpretation. We were saying that this was an interpretation that we could all agree on, that would be useful across the industry, and that could be published and we could point to it. So you'll see in here something like 200 or 300 pages of things like this. So if you want to look up what a lavatory, for example, looks like at LOD 200, 300, 400, and so on, you can look that up in here, and whoever you're transmitting this model to, whether they're around the world or whatever, can also look it up, and you have a common ground. The creation process for this is somewhat interesting because this is really why it gained broad acceptance. We start out with domain experts, and then we make sure that there's a designer and a builder on every domain group. They draft the initial definitions, and then the core group, which includes at least one designer and one builder from each of the major disciplines, the core group gets a hold of it, and then we all beat it up and get it into something that we can all agree on. So the draft from the domain experts satisfies the experts there. Once the core group gets through with it, it now satisfies all the other disciplines as well. So the first time we publish it, we send it out for public comment, and then run it back through the cycle and publish an official version. It's updated every year, but all of the previous versions are kept on the website. And so a project can sign up to, say, the 2019 version, and when the 2020 version comes out, the team has the option of updating to the 2020 or sticking with the 2019. One of the things we found in developing this was that there was a need for an additional LOD between 300 and 400. When we get to really tight coordination and interfaces between systems, we need more than 300, but we don't need a fabrication or shop drawing level model element. So 350 is where we get to interfaces with other building systems. An example might be a slab edge. At 300, that slab edge will be, the location will be accurate, the thickness of the slab will be accurate, and so on. At 350, we now need the embeds for the attachment of the curtain wall. One of the things we did early on was added a little color and shade to the AIA's definitions. We looked at how are we interpreting them in doing the examples through the rest of the spec. The major one, the one that has the most impact, is the interpretation of LOD 300. And what we said was that if something is at LOD 300, it can be measured. The size and the location and so on can be measured directly from the model without referring to called out dimensions. This caused a lot of heartburn at first, even with the architects who were actually on the committee developing this. But it has started to take hold as people realize it's not as scary as it looks because of the specified use approach. In fact, we were, a consulting firm I worked with was doing some work for a major high-end grocery chain on the East Coast. We were doing a workshop for their supply chain at one point, and I asked them, I said, well, who is willing to sign up to this, to allow the contractor, for example, to measure off your 300 elements? Well, the biggest architect in the room stood up and said, we are, and so reluctantly everybody else stood up too, because obviously they had to compete. So it's a market-driven thing that is starting to pervade the market, and it's going to start making a difference in competing for jobs as to whether a firm is willing to sign up for this interpretation or not. And the firms that have found that it's actually quite useful. because you can, when you locate an element, you should be locating accurately anyway to generate the construction drawings. And as long as you limit the reliance according to the G202, you won't get in trouble with these items that are still approximate. So it's important to note that this spec is not a set of requirements. The spec doesn't set down, for example, what should be in SD, DD, and CD, and so on. It's really a dictionary. It provides a language by which users can set down their requirements for various model information exchanges or milestones. And the user writes that story in the table in the G202. So some conclusions then. First of all, sharing models that can be relied on is an emerging trend. It's probably not quite the mainstream yet, but it's well on its way to becoming that. There's little or no case law applying to interpreting BIM. There are some lawsuits out there that have been resolved, so there is some case law, but there's not much. So time will really tell how some of these legal issues will play out. There are risks.
Jim, the
Yes.
fact that there's not a lot of case law, I think speaks
Yes.
to the fact that modeling isn't as inherently risky as some people thought it, 10, 15 years ago.
That's a good point. Yeah. Yeah. So people have actually been sharing these models. The architects have been passing on the model to the contractor, and contractor, well, they may not be laying out items from them. They are using it for coordination, tight coordination of MEP systems. So this has been going on for a while. Thanks, Pat. That's a good point. But there are some risks for the architect, and they're mainly around that unintended information. But the risks can be defined and controlled. And the most important issue is to contractually define the limits of reliance. And the AIA digital practice documents, coupled with the BIM Forum LOD spec, do exactly that. They allow you to contractually define at a very detailed level what can and can't be relied on in your model and to what degree. So Hasti, I think we have a little time to take some questions.
Thank you very much, Jim and Pat, for an excellent presentation. I do invite all attendees to use the question or chat on the right-hand side to enter any questions that they have. We do have a few already coming in. Before we take questions, I do want to just let everyone know that this webinar was recorded and it will be placed on the AIA Contract Documents Learn page. You see the URL there, aiacontracts.org/learn. If you ever have any questions about some of the documents that Jim and Pat mentioned in today's webinar, please feel free to contact AIA docinfo service, and you'll see the email and telephone number there, docinfo@aiacontracts.org. If you ever have any questions about the AIA Contract Documents online service, please contact our technical support. They'll be happy to assist. So again, I invite all attendees to, or any attendees to ask any questions using the chat feature, and we'll go ahead and get started with a few that have already come in. First question, how do you deal with consultants that are uncomfortable with sharing their intellectual property in the cloud?
I guess I could take that on. That is an ongoing question. If you think about it, it's not really much different from 2D drawings. It popped up. This idea popped up in CAD in terms of, I have my proprietary details, and now I'm putting them in this CAD drawing, and somebody else can copy it and take it out and use it. Well, when you think about it, they could do that with paper drawings as well. I mean, if you've got your detail in there, any of your intellectual property that is used for the for the project is out there and can be copied if someone so desires. The documents, the AIA documents, do actually address copyright and ownership, and they do address this idea. And so there is the various consultants do own their own copyright, but just like anything else, I mean, a book is copyrighted too. There's nothing that physically prevents somebody from Xeroxing the thing and selling it on the side. So,
well, there is
does that answer the question?
But people can physically do it. That's for sure.
Exactly.
Yeah. So the bottom line is, modeling hasn't fundamentally changed, or actually changed in any material respect. The underlying ownership and licensing of the design professionals' instruments of service. Those rules that apply to 2D drawings apply to modeling. Now, it's a lot easier to transfer information once it's in a digital form. It's easier to use it for other purposes. So that's not to say that there aren't some legitimate concerns, but the underlying legal framework and the rights of the parties who are providing that information remain the same.
Okay, great. A lot of hesitancy around allowing the various model uses discussed, as well as relying on the disclaimers, is the result of a lack of change of insurance coverage. Parentheses, insurance only covers paper documents. What is the AIA doing to address this?
Yeah, I think that's
yours. Yeah. Actually, insurance really doesn't distinguish between, whether the design professional is creating his or her instruments of service in a paper format or in a, or in a modeling environment. The professional liability policies, talk in terms of, wrongful acts and, and breaches of, of the architect's or the designer's standard of care. And whether that, whether those services are provided in a 2D world or in a, 3D world or 4D world really doesn't matter. So it shouldn't have any effect on insurance coverage.
How can we limit liability of architects for information incorporated into the model through live linked models from other consultants?
That is,
yeah, Jim, go ahead and do that one.
Okay. It's the same issue as, for one thing, you probably don't want to send a live linked model to be relied on by someone else outside of your team. Live linked models are great for working within a design team, or if you're in some sort of a collaborative project delivery model, with the trade contractors on board doing advising. Live link models work great there, but when you're passing them on, like say in a design bid build system, you wouldn't want to pass on a live link model. Just the same as you wouldn't want to pass on a live link CAD drawing. It has to be that exchange has to be some sort of a snapshot that is not mutable. Okay.
Regarding the level of development definitions, do these correspond to standard AIA language in terms of what the architect is typically obligated to provide in their level of detail?
Yes, they are. When we developed the LOD definitions, one of the things we considered is what are useful points to these LODs were, as we saw before, they're sort of like snapshots along the way as the design of an element or an assembly develops. So the snapshots had to be useful. So they are, to some extent, aligned with normal design practice, where there are milestones that we hit in normal design practice and are often included in deliverables at various phases. A key point to note, though, is that they're not the LODs are not aligned. They're not defined by the design phases. For example, 200 does not mean schematic design. If it did, we'd just say schematic design and not worry about labeling it something else. What the LOD definitions provide is a way of defining the phase completion. So if we're talking about 100% DD, not everything in there is going to be at 200 or 300 or whatever, but using the LOD definitions, we can define what it is we mean by 100% DD. And that can be laid out. We've worked with several architects to lay out baseline specifications like that, and it is actually pretty easy to state what a firm's usual practice is for SD, DD, and CD, to state that in LOD language.
Okay, that's unfortunately the only amount of time that we have for questions today. We've already gone over. We do have a number of questions. Please direct any questions that we didn't answer to docinfo. We can also contact attendees directly with any questions that they ask. Again, thank you all. Thank you to our presenters for taking the time to present today. Thank you to all the attendees for taking the time to attend. The webinar will be recorded and on our Learn page, and all registrants will also receive a recording along with the PowerPoint. So thank you all for participating. Take care. Bye-bye.